Welcome to Native Bidaské, Native News Online's weekly spotlight on the people making news and leading change in India.
Welcome to another episode of Native Bidaské. I'm Levi Rickert, your host today. I'm the editor of Native News Online. On June 10th, Leonard Peltier, who many of you know of his plight, who's been in prison for over 47 years, is going to have a parole hearing June 10th. And Peltier was convicted, and many feel wrongfully convicted, of killing two FBI agents on the Oglala Nation back in 1975. And we have with us today as our special guest, Kevin Sharp, who is a former he's a Navy veteran. I always like to bring that up. And he is a former federal judge. And Kevin has been working really very diligently for several years now on the release of Leonard Peltier. And welcome, Kevin. How are you today?
Hey, I'm doing well. Thanks. It's good to see you again, Levi.
Yeah.
Thanks
Hey, real quick. And, many of our viewers are, and most viewers who watch this stream will know that Native News Online has been a real strong advocate for the release of Leonard for many years, and he's having some health issues. He's 80 years old. So can you talk about his current health conditions?
Yeah, yes, I can. Thanks for asking first about his health, because it's as you said, he has been in prison since 1977. He's going on 50 years now, and he will turn 80 in September. He's 79. So, you take all of the health issues that come along with a normal 79-year-old, but then add to that additional health issues. He's got one of the worst being an aortic aneurysm, that is deadly. And it's something that has to be monitored closely. If it ruptures, you die. And he has had that for a number of years, has not been monitored as closely as it should have been. He has heart issues. He has diabetes. Last few times I've seen him, he uses a walker. He had been blind in one eye, left partially blind from a stroke that he had a number of years ago. And his eyesight has gotten worse. Put that on top of not having access to a dentist in years, literally years. He's in bad shape. Things are not going well. And as you mentioned, we've got a parole hearing coming up on June 10th. If they deny parole, I don't know that he makes it to the next one. Not to be too morbid about it, but being realistic, I don't know that he survives. Mm-hmm. And put that on top that he's in Coleman 1, which is a maximum security prison. So you have a frail, in poor health, 80-year-old man in a maximum security prison. Those are dangerous. They're dangerous for young men. He is in danger every day that he's there. So, all of that kind of wraps up into, it's just a perfect storm for something bad to happen if we don't get him out.
Yeah, we really wish him well on his parole. And before we really talk about the parole hearing itself, I want to have our viewers get a little feel for who you are, a former judge, and you and I have had some conversations through the years of why you left the federal bench, and now you're doing what you're doing. And tell us kind of how you got to where you are and how long you've been doing it for, Leonard.
Well, yeah, it's interesting. I did not know who Leonard was. I think I'd heard something about it, but remember, I'm now 61. These events happened in 1975, right? So I'm a young kid playing baseball in Memphis. What happens and what is happening in South Dakota couldn't be any farther removed away from my world. So I didn't know this story. I was a lawyer in Nashville, and was practicing civil rights work, doing discrimination work, kind of plucked out of obscurity in 2010 by the Obama administration and vetted and ultimately nominated for a position on the federal bench. I became a federal district court judge in Nashville, Tennessee, the Middle District of Tennessee, in 2010. While I'm there, I had been a civil lawyer, hadn't had a whole lot of contact with the criminal justice system. So while I'm on the bench, that's really, trial by fire, learning this system. And what really disturbed me were what are known as mandatory minimums. It's where Congress takes out of the judge's hands what the ability to fashion a fair and appropriate sentence for a crime that someone's either pled guilty to or been convicted of, and they mandate what the sentence will be. And I ran into that. The most difficulty I had with that, although I have had problems with it every time it happened, was a young man who was in his early 20s who was convicted of a nonviolent drug offense, and I was mandated to give him 2 life sentences for that. And that was kind of the straw that broke the camel's back, where I had to think, is this where I need to be? Is this justice that's happening here? Am I better off on the bench doing this when I have to and complaining about it, or stepping off the bench and trying to do something about it? I decided to step down, and one of the first things I did was work on clemency for that young man that I had to sentence to life in prison, and ultimately we were successful. And he is out. I heard from him the other day. He's applied to colleges. He's been accepted to Columbia and various top-notch universities around the country. This kid is doing what I knew he could do when I heard him that day in court before I sentenced him. But as part of that process that made the paper, Connie Nelson read that story and thought, well, here's someone who can help Leonard, and had someone send me the files. And so it was interesting the way I came into the Peltier case, because I was a blank slate. I didn't know of Leonard. Maybe I had heard of him, didn't know the story, didn't know how we got there, didn't know any of the cause around him. I just sat down as someone who had been off the bench for, at that point, a year and a half. So I still had the federal judge mindset, as I think I still do. And I just started reading and read the transcript of the case, read the opinions that came out, read the newspaper articles, saw pictures of Leonard's artwork, just kind of learned that as I sat here, just going through the papers and the file in that case. And what really disturbed me were the constitutional violations, the misconduct that I don't think anyone even disputes anymore, the misconduct in the prosecution, the misconduct in the investigation of what happened there at Pine Ridge that day. And I contacted Leonard and said, look, I would like to help you if you want me to do that. And that was in 2019. So here we are, 4.5 years later, still working on freedom for Leonard Peltier. And I think it's not just the thing to do for Leonard, but it's the thing to do for the Constitution, which, I've sworn to uphold and defend the Constitution of the United States 3 times. You mentioned that I'm a Navy veteran. I did it when I joined the Navy. I did it when I was a lawyer for Congress. I swore to uphold the Constitution again when I became a federal judge. And I was really appalled by what I saw and read in the prosecution and investigation of Leonard's case by people who took that same oath. And so, I think I'm not willing to give up on this. If Leonard's not willing to give up on this, I think the country needs Leonard to be free for his remaining days.
Yes, and his hearing's coming up now. There's quite a gap in between the time of hearings. It's not like it happens every year, right? And
no, that's right. 15 years ago, between his 2 hearings, a lot has happened. At his last hearing in 2009, they had at least learned of the hidden ballistics test. And I know I'm kind of jumping around. It seems a little maybe inside for those people who aren't completely familiar with the case. But one of the biggest things that happened in Leonard's case is after the trial was over and he was convicted of being the principal shooter in the killing of 2 FBI agents. Turned out the FBI and the U.S. attorney knew that wasn't true. They had a ballistics test that showed it was not Leonard's weapon that was used to kill these agents, and they knew it, and they hid that. What ends up happening is part of what's known as a habeas corpus petition for constitutional violations is the Court of Appeals says, okay, they withheld this evidence. They should not have withheld this evidence, but the law had changed really while this appeal is going on, and that the standard was that the jury probably would have made a different decision had this really important evidence of the ballistics test not been withheld. And the Court of Appeal says we can't say they probably would have, because the definition of murder includes aiding and abetting, and he was there. And so we don't know how the jury got there, although yes, we do, but you don't get to talk to the jury. And so they could have decided that based on an aiding and abetting theory because he was there. And so we're going to uphold the conviction. Now, interestingly, Judge Heaney, who wrote that opinion on the Eighth Circuit Court of Appeals, came out really about 5 years after he wrote that opinion, calling for, asking for, and supporting clemency for Leonard. So about 1991, the judge on the Court of Appeals is going, man, this case really, really bothers me. And it was the hardest case I've ever had to decide. And he was kind of hamstrung by the change in the law at that time. Otherwise, he would have at least required a new trial for Leonard. And he came out supporting clemency. Now, interestingly, as we move into this parole hearing, 38 of Judge Heaney's former clerks have come forward, written a letter, all signed a letter supporting parole and compassionate release, however it gets done, a release for Leonard. One of those people who signed the letter, 3 of them were actually law clerks to Judge Heaney who worked on this case, but all people who, understand the law. And his job, the one clerk who led this letter, his job was to go through the file, find evidence that Leonard was the trigger man, and he could not do it because it's not there. And the government admits that now. They admit that they don't know who killed the agents. We know it's not Leonard, but they don't know who did it. Yet here we are almost 50 years later, still asking for Leonard to be allowed to go home for his remaining years.
Yeah, and you mentioned that he was there, and so they talk aiding and abetting, but in terms of the time period, 1975 when it happened, there's a volatile time for Pine Ridge Indian Reservation. I mean, 3 years after the takeover of Wounded Knee, actually 2 years, 2 years after the takeover of Wounded Knee, and so many people were going missing, and my understanding, and Leonard was part of the American Indian movement, they would hang together because they felt like it was more security than anything, right? Because they never knew who was going to come up on them and try to separate them, and people go missing, and it was a dark era in the history of South Dakota, and that's 50 years ago, basically, but still a very dark period in American history. So
right, and 50 years have passed, and we can forget. A lot of people who are listening to this or watching this were not alive at that time. You forget how volatile that period of time was. Mm-hmm. And not just at Pine Ridge, although Pine Ridge was kind of the worst of the worst.
Yes,
it was chaos all through this country. You also had the Kent State, the college students who were killed at Kent State.
Sure.
It was just that kind of turmoil. And so context matters. It's important to place Pine Ridge in its contextual time frame. And when you put that, you mentioned the murders, right? You've got the goon squad operating in that area with the help of the United States government.
Yes.
They knew this was a powder keg. And so, when an AIM is there at Pine Ridge to protect those who were not part of the Goon Squad, not part of that faction, that tribal faction. And because those people could not get help from the government, now we know why, because the government was in on it.
Mm-hmm.
They asked AIM to come in and help protect them. That's what they were doing there. And so when you've got, 75, 80 murders, untold number of assaults that are occurring within a 3-year time frame, there's a reason that was called the Reign of Terror.
Mm-hmm.
When someone comes up on the reservation in unmarked cars and plain clothes, I had heard that one of them, in an interview with someone there, one of them was wearing moccasins. Who are they? Why are they here? They did not come in looking like friendlies. And so naturally, a firefight occurs. It was a powder keg. Of course, it was going to occur. And so you have to look at that context. Leonard did not shoot them. They know Leonard didn't shoot these men. But why were they there? What was happening?
Mm-hmm.
It was a tragedy for everybody. You can't diminish the death of those two agents, and you can't diminish the death of Joe Stuntz, who was
Correct.
21 at the time. He was also killed, shot in the head by an agent, never investigated. But it was the time. And you cannot ignore the context of what happened and why it happened and when it happened. All of that has to be considered. And to say now, from the Parole Commission perspective, enough is enough.
Mm-hmm.
Justice now is to release Leonard, let him go home, live out his remaining years, and let's try and have some semblance of healing here. At least start that process. And if we can't be honest about what happened and why the government was there and why they were doing what they were doing, it's going to be difficult to have a real healing. But allowing Leonard to walk out of that maximum security prison as an 80-year-old man is a great start. And it's the thing to do. And it's what the Constitution requires, I think.
Yeah.
It's what justice requires.
So tell us about some of the particulars of the hearing itself on June 10th. And where is it going to take place? Will it take place at Coleman, and tell us a little bit about the setting and what will happen? So
it does take place at Coleman. The Parole Commission will have a hearing officer there who will take evidence. There will be witnesses. We don't know precisely who all the witnesses are right now. Some of that testimony will be in written form, and some of it will be live. We'll hear from folks on the government side. We'll hear from folks who are supportive. For example, we hope to hear from the doctor who last examined and has done the last several series of independent medical exams of Leonard, to talk about, from a doctor's perspective, not just mine, not Leonard's. The physician who examined him will say, "Let me tell you about his health." One of Leonard's supporters is the U.S. attorney who supervised the appeals. Right. So this happens in 1975. Jimmy Carter has an appointment coming in. The case is actually tried in 1977. You've got a new U.S. attorney, a guy named James Reynolds. And James didn't supervise the actual trial of the case because it had been worked up before he got there, but he did supervise the appeals and the habeas petitions, the constitutional petitions that came later. James Reynolds is a supporter of parole and clemency for Leonard. He acknowledges the things that his office did that were improper, that were constitutional violations. He acknowledges that they could not prove Leonard committed a crime that day, and he's in support. I mentioned the clerks for Judge Heaney. Judge Heaney unfortunately died years ago, but he did write a letter in support of Leonard before he passed away. You've got those witnesses. You've got witnesses who, for Leonard, in support of Leonard, who were there, who can testify about the conditions and the context that we talked about earlier, because context matters. And then there will be witnesses who can talk about what life will look like after, if Leonard is released on parole. What does it look like when he goes back home to the Turtle Mountain Band of Chippewa Reservation in North Dakota? What does that look like? What's his housing look like? What does his health care look like? Be able to explain, for those of us who don't understand the way elders are viewed and treated inside the Native American community. It's important to have that information for the hearing officer. A lot of times in a European based community, someone walks out of prison, you're on your own, and it really doesn't matter, what your age is. But that's not the case. As you obviously know, it's not the case when he goes back to his reservation. There are going to be people and healthcare services and meals, transportation, all of these things that are going to be important to someone of his age who's been in prison for nearly 50 years. Reentry is not going to be easy, so we'll have somebody there to talk about those kind of things. I know this case. I'll be able to talk about how we got here. I'll be able to talk about, to the extent that we can, that the hearing officer wants to hear about it, the admitted racist juror. That never came up in any of the early filings, but you had a juror who said, I'm prejudiced, her words, not mine, I'm prejudiced against Indians. And the court says, well, can you be fair? And she said, yeah, I can still be fair. Okay, good enough for me. You're thinking, this blows my mind. That's, if that happened today, you get a new trial. You can't waive your Sixth Amendment right to a fair and impartial jury. So there are those kind of things that I can address, and Leonard will be able to address the hearing officer as well. The government will have people there arguing that he shouldn't be released, that somehow this 80-year-old man who's in poor health is a danger to the community. The biggest danger from Leonard Peltier is falling. That's the danger for Leonard. No one else is in danger, and they know that. But we'll see. We've got to present that evidence and make the best case that we can. And support from the community is important. Writing, emailing the parole commission, because that's who will ultimately decide. The commissioners on the parole commission will ultimately decide whether Leonard gets to go home.
And at the end of this stream, we will post the information with a slide where people need to write in, because by the time this is shown, there'll still be time for the June 10th hearing. And that's why we wanted you to come on early, Kevin. Is and you and I have discussed this before. Typically, parole boards want to hear that there's an admission of guilt and that there's some remorse. And I would imagine there is some remorse on his part for the whole situation. The whole thing's tragic. But Leonard has maintained his innocence, and we believe he's innocent. So how does that play into this at this juncture?
Well, it's difficult, because if someone wants him to admit that he shot 2 agents at point blank range, he's not going to do it, because he didn't do it, and there's no evidence that he did it. So that there are people.
You shouldn't lie about something you didn't commit, right? A crime you did not commit. Yeah.
Right. So it's an issue outside of Leonard's, that you have people who will confess to guilt, because it gets them a lesser sentence, when in fact they do it. Right. So you make that kind of cost benefit analysis. Leonard's not willing to do that, nor should he.
Yeah.
He didn't do it. They can say it over and over again, but there is zero evidence. And so you have a guy saying, I didn't do it, and there's no evidence that he did. I don't know what you want him to do.
Exactly.
What he does do, though, is, it's more than some remorse. what happened there, and not just on that day, right? There was June 26th, and that was tragic. But you can also feel remorse for everything that culminated, on that Jumping Bull Ranch that day at that time, and that people were killed is tragic. And Leonard has said over and over again, I've read it, I've seen transcript of him saying it. He has said it to me. He does feel badly for everything that happened.
Mhm.
He
Hey,
feels,
from afar, I feel remorse. I mean, I look at
right.
history of American Indians, not just the incident in El Gala, but certainly throughout history. It's just very remorseful when I study it and read it and write about it now. I'm very remorseful. It's like, wow.
Right. It's heartbreaking. And you
It-
can't not your heart can't not be broken when you hear the stories of boarding schools, of
correct.
what Leonard was a victim. And
Mhm.
Leonard's little 6-year-old sister was a victim, and his cousin, and thousands of others. You cannot pull that out of the context of what happened.
Mhm.
Can't understand what happened there at Oglala without understanding what happened 2 years earlier, as you mentioned, at Wounded Knee. And you can't understand what happened at Wounded Knee in '73 if you don't understand Wounded Knee in 1890.
Correct. Correct.
All of that is just uh, gut wrenching
Mhm.
that we got to that point, and that there were more victims in that long hundreds of year history of abuse and murder and theft. That's It's all part of it, and it's all heartbreaking. And Leonard does have remorse for that, and has always maintained his remorse. Nobody wanted those two young men to die. Nobody wanted Joe Stunts to die, except for maybe the guy that shot him, because there's no evidence that Joe was doing anything but standing there.
Mhm.
So, but right, that's part of it, and whoever did that can be forgiven. Um, it is time to embrace what happened, and take the next step in this country's history, because this is all part of it, and it is all tragic, and we
Yeah.
all feel bad about that.
And I mean, I obviously it's tragic that two FBI agents died.
Yeah,
But,
absolutely.
but I often think about John Hinckley, who's been released, and he shot the president of the United States, Ronald Reagan. And so and Leonard did not shoot them. So I
Right.
say free Leonard Peltier. You see that on bumper stickers, but it's more than just a slogan of that. It's
Right.
time to free him. And Kevin, give us some last words here, because I appreciate everything you've done through the years to help work towards that release, which we're still hoping and praying for.
Yeah, I'm still optimistic. Thank you for having me on. I think, the important thing about all of that we've talked about today, and everyone who reads this, when you say free Leonard Peltier, it's more than about Leonard Peltier. This is so moved beyond one man and one cause, right? This is all the things that we talked about. It's all the context of that. It's the hundreds of years of history, and it's the continuing violations that we see. Freeing Leonard Peltier is a step in a process, and a process of remedying past wrongs, and a process of healing past pains, and a process of moving forward with respect for each other, and respect for their human rights. So it's more than about Leonard. That's another reason why Leonard needs to be set free, because I didn't say this, but I'll borrow it from someone else. As long as Leonard's in prison, we're all in prison.
Mm.
When Leonard is free, it'll be a step for all of us to be freer. This has to happen, and it needs to happen now. It's been too long.
Yeah.
Thank you
Well,
for staying on time.
our prayers will be with you and Leonard both on June 10th. And so thank you again for everything you've done. And to our audience, Chimigwich, we've been talking to Kevin Sharp, who will represent Leonard Peltier at the parole hearing on June 10th. So keep Leonard Peltier in your prayers. He's approaching 80 years old and in very, very poor health, complications from diabetes, and on and on. So Thank you for watching another episode of Native Bidaské. We'll be back next week with a very special guest, Chi Miigwech.
If you appreciate what we do here at Native News Online, we invite you to donate to support our continued work covering Indian country. You can scan this code with your smartphone or go to the link located below this video to donate today. We greatly appreciate your support. Please be sure to subscribe to our YouTube channel and follow us on Twitter, Facebook, and Instagram. And be sure to scan this code or go to the link below to subscribe to our newsletter. Thank you for joining us today, and please be sure to join us again next week for another episode of Native Bidaské. Chi Miigwech.